Okay, well, hello and welcome to our meeting of the Utah County Commissioners. As usual, we will begin with a prayer, reading, or a thought, and the Pledge of Allegiance. Do we have any volunteers for either of those? Okay, I'll look up here. Which one?
I'll do the prayer.
Okay, we have volunteer for a prayer, and then Commissioner Lee will lead us in the pledge. Okay, if you could come to the podium, that would be great. And state your name. That would be.
My name is Leah White. Our dear Heavenly Father, we are so grateful that we live in this free country where we have the rights and ability to worship how we choose, to own land, to start businesses, to live our lives in accordance with the laws of the land, the way we choose and the way we like. And we're grateful that we get to be here in this meeting today with our elected officials who work hard to make sure that things go well in this part of the country and the world. We're grateful for their time and effort and their thought that they put into all that goes here in this county. And we're grateful to be a part of Utah County and be a part of this meeting. We pray that thy spirit will be with us and that we may have peace and enlightenment, and that this may be a wonderful time to work through some issues and make some decisions. And we say this in the name of Jesus Christ. Amen.
Amen.
Thank you, Leah.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, we will now go through the process of building our agenda. We have a published consent agenda with 16 items, and we have 27 items on our published regular agenda. Anything that we do not hold for discussion will be approved as if it were on our consent agenda. The first item I want to hold for discussion is just item 13 on consent. A quick question on that. I think we can also hold number 15 for consent, or for discussion on consent. Any other items needed from consent?
I don't necessarily want to hold number 14, but that one is to ratify a signature, talking about the Zoom video communications. And I would hope that as we're looking through that, that should be COVID-19 funding. And I just wanted to make sure and just point that out.
I agree. Make a note there that that's from the COVID funds. Okay. Turning to the regular agenda. Anything here on the first page anyone needs to hold?
I don't know if we need to hold number 2 or just to clarify that approving that authorization is on the final Lehigh approved version. There's bunches of versions in there.
Final
correct.
approved. I'm fine with that annotation as well.
Also, there was attached a concept plan which Richard Nielsen has reviewed and agreed with as well.
Okay. So noting the final, that can stay on consent. We have item number 12. I would be fine holding that for discussion or just noting it for denial.
Let's hold it.
Hold it. I have a brief comment on 14, so I'll hold 14. imagine if we're holding 12, we'd like to hold 17 as well.
Right?
Okay. Any other items to be held?
We could, hold number 18, one that I put on there, so it's interesting that I'm holding it, but I think that, just for clarification. And then, could we hold number 19? And I believe, number 21, we need to take action unless we're just saying that we're taking action by leaving it on consent.
Okay, we can just hold it and take the action. Okay,
That's it.
that's it. Okay, then we will turn to, looks like consent 13. Richard, I noticed this is good news. This means that the watershed program that's been worked on, there's a grant that's been received.
Correct.
I just wanted to make sure I understood the obligations that we were entering into as we accept these funds. Does that come with a match requirement on our part?
Okay, so on this one, Richard Nelson, Public Works, this does not have a match on the county component. This is for what they call the Plan EA. So it's the environmental assessment for the watershed ops, work that we've requested. Maybe just a little bit of background. This is the work that was originally part of our emergency watershed protection application, the portion that was pulled out by NRCS, and they said, let's do that under the watershed ops. It's a little bit longer time frame, but it does come, there's components of that, even on the construction side, that come as a 100% cost from NRCS. There's others, depending on what it is, that may be the 75-25 like we're seeing on EWP. This portion of it with the design work and the Plan EA is all fully funded by NRCS. So this is the paperwork. It's about $988,000 that will come. We will then enter into an agreement with the designer, and they'll go through and do the work, and NRCS will pay the bill on that. So.
Okay, thank you for clarifying that. I'd entertain a motion on this one.
Move to approve consent agenda item number 13.
Second?
Given a motion and a second to approve consent item number 13. All in favor say aye.
Aye.
Aye. That passes 3-0. Number 15.
Ralph Barnes, Human Resources. You want to start with questions?
Ralph, do you want to just give a very brief synopsis of what we're doing here with this agenda item?
Yeah. So Senate Bill 56 was passed for URS to enhance Tier 2 public safety benefits for URS. It increases the multiplier to 2.0 instead of 1.5. In other words, years of service will be calculated using that higher multiplier. It also enhances the death benefit for public safety officers in Tier 2 to be the greater of 30% of their final average salary, or as in if they had retired the day before they died, whichever is greater. So those are the changes. The reason why this was brought to the legislature was to hopefully improve the attraction and retention of law enforcement officers, especially Tier 2, because it is significantly less of a benefit than Tier 1. They're trying to make it so it's not as much of an offset. And so that was the why. The how is that the state has determined that the state will pick up the extra cost for the state employees, but they're putting it on the counties and local governments to pick up the extra cost. Now, there is an option for the local governments to pass some of that on to employees and make it an employee contribution, which is 2.27 percent of the increase, and that's the equivalent of about $99,000 a year annually, annualized.
That collectively the employees would have to,
That is correct. So the options are either the employees would pay that to have this enhanced benefit, or the county will pay it as a pickup. Now, there are some, tax implications to the employee if the employee has to pay it. So there's a slight increase in the cost to employee that way. If it's, paid for by the county, it's considered a taxable contribution. So there's no tax, implication on that whatsoever. So that's really the intent, that's the cost. There is, the rates typically increase in one area or another each year with URS. Not all of the plans or systems increase, but something usually increases. So it's not unusual, but this one is, specifically, geared towards, tier 2 public safety.
thank you for that overview. This is an area where I'm curious, and I would welcome public comment. I'd welcome comment from Sheriff Smith or his staff on this. This is an area that, I've heard of the challenge. Sheriff will speak about how challenging it is to attract new talent into law enforcement right now. And so I understand that. And when I think of the total, I typically think about this in total compensation, though. And when you're attracting new talent, you would anticipate that they're looking at total compensation. And this is not necessarily changing total compensation, it's just shifting the mix to higher benefits, higher retirement benefits, rather than increasing wages. And this is where I have questions about this, because it kind of feels like over the last few decades, the private sector has gone the opposite direction. The private sector is going heavier to cash compensation. The benefits, the health benefits, the retirement benefits are being reduced. And in government, we're going the opposite direction. And that makes it more and more difficult for us to compete with the private market. And so that's kind of the question that I have, is even if we were going to take the same amount of dollars here to enhance the compensation package of our sheriff's deputies, would it be better to apply those to wage increases or to benefit enhancements, right? Because you could argue that this might further that gap. It might further that gap, so someone coming out of training school or coming out of high school, even when they're trying to think of their path, if they were just to look at starting salaries, they might not realize that, the benefits are so much higher in this type of role. And so that's a concerning trend for me. I feel like it's probably better for government to try to match what the private sector is doing. I don't know if there's any comments from those who have supported this, or if you have comments on this.
Well, I can say that, generally, just looking at, the benefits plan at a high level, it is, the retirement plan that is, typically richer than what you find in the private sector. The other, parts of the plan are pretty similar in a lot of ways. So that is where you see the difference. And so I can see what you're saying. Increasing that further could, increase the gap. Putting this into wages instead, I think, is a risky proposition, because then there's the expectation that you have to continue to do so just to stay up with that, or to stay up with inflation. And then there's always the cost of living, which may or may not be a factor. But when we go out to market, we look at similar organizations, public law enforcement organizations, to see what they're paying, and hopefully this will be taken into consideration, because all of the counties except for one are doing this, the pickups. So you would think that we'd at least have apples to apples when we're looking at wages and benefits for law enforcement when we do a market study. So I hope that will be taken into consideration. I can help make sure that is so, but it is tricky when the legislature kind of throws this on us, and we have to make a decision whether we're going to pay or whether the employee's going to pay.
Ralph, I'm supportive of this. I frankly think that what the legislature did a few years ago with Tier 1 and Tier 2 was a mistake. And so this doesn't get us all the way there. It's not even close in a lot of respects, but at least it gives us some stepping stones in the right direction. So I'm supportive of at least walking that direction. And I think as an organization or as a law enforcement organization, things have to kind of move together. It's pretty hard to move on separate bases. And so this is a step. And it's unfortunate, I think, that one of the counties decides they want to do something different, but so be it. Hopefully we'll move in a direction that makes sense.
Afternoon, Commissioners. Sheriff Smith. I agree with what you're saying, Commissioner Lee, and also with Ralph. I think, to your point, Tanner, I think we're competing. The problem is we're not just competing with the commercial market out there. We're also competing with ourselves. So it's a little bit bigger problem when we're finding there's so many things going into the equation right now, I think, of why people want to find a job outside of law enforcement. And you're even seeing those that are in it seriously question, do I want to stay in it, because of all the different pressures that we're feeling right now, especially, you know, around the world, but especially in our nation, of what's expected of law enforcement, and in the end what the wages are. So you have the wages, one thing, and I think you're right, when somebody's first getting into it, that wage is the attractor, right? Well, here's the wage, but you know, if we're going to compete with the market out there outside of law enforcement, I don't even know how we begin to do that, because we're not. So to say, you know, we need to do that, then we need to get really serious about doing that, because we're not getting people come here when they go out and look around and find out you can get a lot easier job or less risk in your job for more money. But then once you find those people that there's this innate, you know what, there's this burning sensation, my calling in life is to be in law enforcement. Now we're competing within the market with each other. And it goes back to what Ralph said, when you have different entities that are, for instance, 28 of the 29 counties said, we're gonna do this, well, that's when that shopping starts to occur, and officers are going, well, I can do the same job over here and get a better benefit plus a little bit better money. So I strongly support doing this. I think we need to stay competitive, but I agree with what you're saying, Commissioner Ainge, that on the other end, there's this whole other area, and I don't think as a government entity we'll ever be able to really compete with the market out there. But we need good people in this profession, so every little thing we can do is very much appreciated.
So on that front, then, is it your sense that, I know maybe it's a little bit different for someone coming in or deciding whether they want to pursue a career in law enforcement. But to your point, right now, we're also competing with other agencies, poaching, you know, hiring your deputies that you've put a lot of resources in and training.
Yes, constantly.
And so you feel like this will help you retain people, even if you were able to say, hey, well, we actually pay a little bit more to compensate for the fact that we don't cover this. You think it would be easier as a retention tool just to have the same benefits that every other county is?
I do. And not just every other county, every other police agency around us, you know, every city, you know, if they're doing something that we're not, that's when people start to shop and say, oh, it's the same job over here, but I'm getting a little bit better. And it used to, when I started in law enforcement, you know, you stuck with your agency and you wrote it out, and in the world and in the market, you just don't see that anymore. There's a trend of, you know, just popping around, going wherever the grass is greener, and we need to do our best to keep our grass green here.
Okay, thank you, appreciate that. Okay,
Do you have any more questions for me?
I don't. I'd entertain a motion on this one.
I'll make a motion that we approve and adopt the resolution as stated in number 15 on our published consent agenda.
Second.
We have a motion and a second to approve item number 15. All in favor say aye.
Aye.
Aye. That passes 3-0. Okay, we go to regular agenda item 12.
Ready for me?
Ready for you.
Bryce Armstrong, Community Development. If you recall, this is an item that was before you several times, most recently about a year ago, for a rezone of property at the mouth or into Payson Canyon. And at the time, the commission determined that they would entertain approving this subject to a development agreement being entered into with the county and all property owners affected. And so for several reasons, it's been requested that this be brought back for discussion, one of which is one of the subject properties has since been annexed into Payson City. And then one of the other reasons is the Troyers have indicated to at least the attorney's office as they've been working on the development agreement, and perhaps some of you, that they're having trouble getting one of the parties to sign and want to know what their options were. So it was my understanding that that would then need to be amended because it seemed like it was the commission's direction that all property owners be subject to this that are subject to the rezone. So this is kind of in companionship with item number 17, I believe. That's also the actual development agreement.
Okay.
So that's why we're here.
And is there anyone here to speak to this item? Or on the phone?
Now, I'm not, this is Rob Moore, County Attorney's Office. Now, I was asked to put this on, at least number 17 on the agenda. I did not notify the Troyers, so I don't know if someone else did. So they may not know about this matter today. So if you want to have them here, I recommend continuing it and then have them here to discuss that, whatever you'd like to do. But Bryce is correct. I did prepare a development agreement at your request last summer and gave it to the Troyers. The development agreement essentially did what we talked about, which would basically, if you rezone the property, the minimum acreage required to develop would be 9 acres as opposed to 5 acres in the RA5 zone. And so I prepared that development agreement, and Mr. Troyer has taken that around, and that was with representation to my office that there was one property owner who was unwilling to sign off on the development agreement. And the reason I was given was because of their age. They didn't feel like they wanted to do anything given their age. And so he came to me a couple times, and I suggested he talk to you because it was your discussion last time that led to having all the signatures required beyond this. But I understand further today that the one property owner who is not signing off on this is associated or tied to another piece of property as well, and that might create a problem for us. They have what's called a declaration of zoning lot, where they've tied 2 pieces of property together, so one half signed and one half is not signed, basically.
Given some uncertainty around this and the lack of the opportunity to speak with individuals, I would probably suggest continuing. I'm happy to hear from them, and we'll look into the development agreement and where it's at, but I'd want to hear from them and their perspectives, and if there are people objected, I'd love to have the opportunity to hear from them as well.
And I think that's fair that we at least have them here. I just assumed that they would probably show up. I don't know why I assumed that, but anyway, it was assumed they'd show up, or at least be notified. Couple points though, since we're on this topic, that piece of property, it's approximately 120 acres that we're talking about with multiple landowners, and this one that it does not want to sign and be a part of it is about 6 acres, roughly. And so you're talking about a small minority. And then we have the other group, I don't know how big that acreage is, that was annexed in. And so I think it's fair that we at least look at amending it. There was a certain amount, I felt like there was an agreement that going with the development side and having that development agreement in place, would allow them to move forward. And that 9 acres, was kind of a compromise position from us to say, normally it's 5, and to move it to 9, And I talked with Bryce about that, and I said, are there any right now that maybe have 5 acres that would feel like they're losing something on that? And we kind of, you know, walked down through that a little bit, but, anyway, I'm fine with, allowing at least them to be notified so they can be here, so we can have that conversation. So if it's all right, I'll make a motion that we continue item number 14 and 17 till our next commission meeting so they can be notified.
You want 14 or
That's 12.
12?
What do I say? Oh, 12 and 17.
I'll second that.
Okay, we have a motion and a second to continue items 12 and 17. All in favor, say aye.
Aye.
Aye. That passes 3-0.
Would you like my office to notify Mr. Troyer?
Please.
That'd be great.
Okay, item number 14. I just had a simple question here.
Yes. Yvette Rice, Sheriff's Office.
Hi. The one is, I heard that maybe there's one that's coming on the enforcement side as well. So we could just continue this and wait on the enforcement. I also wondered if we shouldn't increase this just a little bit more.
Thank you for allowing the opportunity for further discussion on this. I had an extended conversation with Sheriff Smith this afternoon about this topic specifically. The fee that was requested, you've obviously seen the calculation and how we arrived to that calculation. It does cover the cost of the deputy providing the security. However, the overhead component of that is not factored in. So I would agree, and I believe Sheriff Smith would agree at this point, that we probably need to increase the fee. So going back to patrol's law enforcement fee, it's been a couple of years since we updated it. Currently, that contract fee is at $67.50 an hour. The difference between that fee and the security fee comes down to an item of equipment that's used, a vehicle. We don't utilize a vehicle for security purposes for events on county properties or in county facilities. Having said that, the last time I did research with respect to enforcement fees, those contract costs from various law enforcement agencies outside of the sheriff's office ranged from about $75 to $100 an hour. And Sheriff Smith, I believe, has found the same kind of information. We don't really have anything to compare with relation to the security fee. So this is kind of a new area. I think officially it's the first time we've ever enacted an ordinance to establish a security fee. We believe that it would be more reasonable to charge probably a flat fee of $70 an hour with relation to security contracts. That's what we would propose. We understand that the ordinance would have to be modified, and if you would like to hear both of those items together, I have no problem with that, if you'll just give me some direction on how you'd like to proceed.
So I'm all for, I agree. I think when I saw that cost formula, there was some additional areas of overhead and administration, which quite frankly are even more important to pass along on these outsourced services, because it does take some additional legwork just to get the contracts.
Right, and maybe
running.
for the benefit of the citizens that are listening, those kinds of considerations would be things like the involvement of layers of supervision within the process. So scheduling deputies to participate in the security for events, the billing of the event. There's a lot of paperwork involved in processing the billing and getting it to the correct persons for payment to the county. If we receive any kind of citizen complaint in relation to an event, that requires investigative time for supervisors, potential additional documentation. If there's a criminal incident or there's some other incident that occurs, that's just more investigative time. So it may seem like a pretty good sized chunk in addition to what we initially requested. Ultimately, I think it's a reasonable fee.
Do we have any estimate or benchmark of how this compares to like what Salt Lake County would charge?
I don't know that Salt Lake County provides security fees. I don't know, I haven't been able to find that information. Most agencies only provide law enforcement fees. So they want the full benefit of a full-time law enforcement officer with a department vehicle, able to deal with any law enforcement issue that arises. So that's the difference, and that's kind of the quandary that we've had.
But you feel like a $70 flat number is appropriate
I do.
after thinking about some of those overhead
I
costs?
do. I think it reasonably covers the cost for all levels of completing that process. But the other part of that is I don't think it's an unreasonable fee or a gouge to the citizens. And that's always one of my considerations and concerns as I've tried to update fees in the past.
Okay. And do you have a preference of whether we adopt that now or whether we wait for the enforcement?
I don't have a preference, whatever you think is reasonable. My question would be, do we need to technically modify the ordinance? The ordinance does specify $59 an hour. So I
Well,
don't
but
know
we
the
haven't,
process
we
of
haven't
that.
adopted that yet, right? So that's what today is, so
Right.
it'd be easier to, it'd be easy to just switch that,
Okay.
the numbers.
All right, whatever's appropriate.
My preference would be, let us take a closer look at enforcement and come back with both of these to you. That would be my preference. I don't think we're on any urgent need right now, are we?
No.
Okay.
So, let us do that. We'll get some better data, see if we can find some better stuff on judicial.
Do-
Get that number where everybody feels.
Do you have a,
We wanna, in the end of the day, we wanna make sure the county's covered, but we also wanna make sure it's a fair price for those that need the service.
procedurally, do you have a date that you anticipate that, or would it be easier if we just strike this and then bring it back when they're both ready?
I don't know how long it will take Patrol to provide that information for you. Patrol is not my function anymore. That would be something that the sheriff would have to
I-
take back to the
Next
chief
meeting?
deputy to make the
I think
request.
we wanted to put it on next agenda. We could have it ready for you.
Okay, that's the question at hand. Okay, perfect. I'd go ahead and move then that we continue regular agenda item number 14 until our next regularly scheduled meeting.
Second?
you.
We have a motion and a second on item 14. All in favor, say aye.
Aye.
Aye. That passes 3-0. Okay, item number 18.
All right, I put this one on the agenda in working down through it with the disruption that goes on with COVID-19 and businesses in general and the concerns that we all are aware of and concerns about it. One of them that came up was the personal property tax. And the personal property tax has components to it in which you have penalties and interests that are attached after May 15th. And so the reason why I put this ordinance on here is pretty simple, and I'll explain in kind of a second. There's two parts to it, but it says the county may authorize a reduction or waiver of penalties imposed under Utah Code 59.2.306 if it adopts a procedure for the review and approves the reduction and waivers by an ordinance. And that's what this is an ordinance that's put into place so that we can, in fact, put this off for this is personal property again. The second part of this in the way of the tax is the interest. And Utah County does the interest, we do it a little different than some of the other counties in that our assessing office bills, and then we don't actually start the interest payment until they've received the bill. And so in talking with Chris, and I don't know if Chris is here, maybe Anthony can speak a little bit to that, in that it feels like that in doing a combination with this ordinance and also with the interest component part, that we can probably help some of the businesses as they're working through this issue. Anthony, you on the line?
Yes, I am.
Did you want to touch a little bit on that interest component part?
Sure. So other counties, how they do it is they require payment due on the same date that the application is filed. So May 15th is the date for application to be turned in. And so if you didn't file on May 15th, you would get a penalty, and also interest would start to accrue immediately in other counties. And so how those other counties are addressing it is they've instructed their assessor's office to prepare a file for each and every person that files after that deadline within the window, a green folder application. And so that creates the work for those offices. And as Commissioner Lee pointed out, our county does a little differently, where May 15th is the deadline for the application, and that's when the penalty would be assessed. But the billing is actually sent out by the assessor's office separately. And so what Chris Paulson has mentioned that his office will do to put off interest is delaying the sending of the bills. So that way we don't have to worry about trying to prepare applications in mass for tons of people that may have to file late. We can just send them out all together at a later date after the June 15th deadline. And then this process would then also take care of the penalties. If they file within that window, then their penalties would be waived.
Thank you. And so this is an attempt to kind of help out the businesses there as we go through this time. But as mentioned there, if we went the other route, which some of the other counties are doing, it would increase a lot of volume of work on the county side, which I was not really in favor of. But because we're doing it the way we're doing it, this ordinance now will just help to waive the penalties part of it, and then the interest part will be done on its own.
Okay, just one question. I mean, I think this is great. I think I support this. We're gonna continue having conversations about other types of programs that might help the businesses through this difficult time. Josh, is this something that, I guess Chris and Josh, the administration of this is kind of been seen, approved by your respective departments, and you think it's not gonna be a problem?
Yeah, I think this is doable.
Okay,
And just to clarify, on personal property tax, some people don't always realize this, and it's not directly relevant really to this, because this is saying that because of the emergency this year, people may need a delay in paying their personal property tax. But any change to tax rates, which we've discussed previously, doesn't impact your personal property tax payment for another year. Just so that everyone's clear about that. So real property, it's impacted immediately when adopted, but personal property, actually, there's a delay in when that kicks in.
It actually uses the prior year rate, because typically it's paid before the rate is even set. So that's actually in code. The other thing we're doing, as you know, May 15th was the deadline. We had 75% of businesses file. And so we are leaving the web filing open, and people can continue to file going forward. Usually we close that down, but
Chris, out of curiosity, how far off of traditional is that? I mean,
usually we're in the 80s, so we're not really that far off. Corporations typically do file, and 90% of the funds come from corporations. So I don't think we're gonna be that far off in collections. So we're just gonna delay the collection. And so, yeah.
But they do have to file. If they just can't, this can't be claimed unless they have to file though.
Everyone has to file, even to claim the exemption.
Right.
And so that's, so we're also extending the exemption out. Usually the exemption terminates on the 15th, but we're gonna extend that out also.
thank you.
thank you.
Okay, if there's no other questions, I would entertain a motion.
I'd like to make a motion that we approve and adopt the ordinance as stated in number 18 on our published consent agenda,
Second?
published regular agenda.
We have a motion and a second to approve item 18 as on our regular agenda. All in favor, say aye.
Aye.
Aye, that passes 3-0. Number 19.
So this is the one that I asked. During our budget process last year, we talked about this position. And if I remember correctly from our conversations, we asked to see if you could go find some other funding for it. And apparently you have not been able to, and I understand that's not necessarily the question. But I wanted to hold this for maybe some conversation, because this is a budgetary matter in which if we pass this now, typically we hold staffing plans, or staffing positions and so forth through the next year, which is a budgeting process. I would like to think about maybe saying that we approve this through the remainder of the year, but it needs to be reconsidered at our budget process time, in hopes that maybe still there might be an opportunity to go see if we can find that funding source from some other place. That was the only reason why I held this, is to have that kind of conversation.
Yes, thank you. And Rebecca Martell, Children's Justice Center. So I've been working pretty closely with Tanner on this as my portfolio commissioner. And we thought we had other funding secured for this through the state appropriations. And I received word that since they called special session, they are cutting any new building
Well,
block funding.
and if I may, isn't it, it was not just we thought, I mean, we actually
It was
received
approved.
notice
It
that
was
it was, that
approved.
it was approved in this session, but then as they've made their budget cuts, they've revoked that funding.
Unfortunately, yes.
So my hope is that
Right.
we can still find, and so I think the way to keep it on there for discussion is to maybe is to approve this, this funding for it, with the caveat that when we have our budgeting, times again, that we continue to look for
Absolutely.
funding sources.
And that's my hope as well, is that maybe we can work something out with the state, maybe paying half and half for the position, so.
And Rebecca, I think I would appreciate your commentary. I know we've spoken a little bit about this, but remind me, it's a pretty horrific statistic actually, but the level of abuse, the percentage that we're seeing of children that are abused, that is someone in their own household.
Yes. So statewide numbers from DCFS is about 68%. When I pulled our own numbers from our center, we're looking at still above 50%.
And the scary thing about that is that we have seen during COVID-19 an increase in domestic violence. That much we know, and it can be inferred that there's a correlation there, and that you're seeing some pent-up demand for the services of Children's Justice Center. Is that a fair statement? What is your research pointing you to?
Yeah, what we're seeing right now is when COVID started, we saw a huge decrease in cases as kids went into isolation. But now that things are opening up, we're getting a pretty big increase in cases. And so it's really paramount for us to open this second office so that we can maintain social distancing between families and meet the demands of our community.
Well, I mean, and that's why I've wanted to be supportive, is to make sure that through this time, especially as other funding goes away, that you're there to provide those services to the kids in need. I also do think that there should be costs that you're incurring that are covered by the COVID-19 grants that we're receiving. To the extent there is increased demand that's related to that, or the video, conferencing or other services that you're doing, or even to have a second location to be able to facilitate more social distancing and be able to reach more kids. I just want to make sure that we're being diligent in making sure that some of these expenses, if they are covered by the CARES Act funds, are being earmarked that way.
Right, and I will be working with Peter, who is the county COVID budget person on those issues. So,
Okay, thank you.
Thank you.
thank you.
Well, I'd like to make a motion. I'd like to make a motion that we approve and adopt the resolution as stated in number 19 on our published regular agenda, with an asterisk on there that this is for this year's process, through this year, and that during our budgeting process, it will come back up for more discussion, and we'll continue to look for funding sources to fulfill this long term.
Second?
We have a motion and a second as stated for regular agenda item number 19. All in favor say aye.
Aye.
Aye. That passes 3-0. I think we had a question of whether we needed to take action on 21. I guess I'll turn it to you, Commissioner Ivie, for 21.
Right. So Rob, do you want to comment briefly too? Obviously, I'll introduce this. Recently, the Utah House passed House Bill 297, which opened up opportunities for the utilization of yurts throughout the county. This proposal is to take action to refer to the Planning Commission, looking at adoptions to our county land use ordinances of incorporation of this House bill so that we're consistent with state law and also in opening up those particular opportunities.
Yeah, the Rob Moore County Attorney's Office, that's correct. We had actually anticipated this amendments. The county commission previously made some adjustments to our county code and our county land use ordinance. We need to make a few more, and Bryce had anticipated that, as has Kurt Bertelson, our fire marshal, and they both have drafted amendments. Bryce actually had them scheduled to be on for the June meeting for the planning commission, and so if you refer this to it, it'll just make sure that happens. But he's got a draft already, and I've seen it and reviewed it, and it was fine with that. Kirk sent me a draft of the ordinance, and I'm fine with that. We may make a couple tweaks, but I think we're there. So there will be just a couple of things that need to be done. So besides what's going to the planning commission, we'll have to bring to you a modification of the county code as well that Kirk has recommended. So, and I'm working with Steve to see if there's Steve Kitchen, to see if there's anything in our building portion of our county code that needs to be modified. Okay.
Perfect.
Thank you.
Thank you.
I'd go ahead and then move that we take action and refer regular agenda item number 21 to the Planning Commission.
Second?
We have a motion and a second to refer item 21 to the planning commission. All in favor say aye.
Aye.
Aye. That passes 3-0. My understanding is that we would need 25, 26, and 27, but not 24 today.
Motion to strike regular agenda item number 24.
Second?
We have a motion and a second to strike 24. All in favor say aye.
Aye.
Aye. That passes 3-0.
I'll move that we approve and set a date, time, and location for the closed meetings as outlined in regular agenda items numbers 25, 26, and 27 for today's date, following the completion of the regular agenda.
Second.
We have a motion and a second to have those closed meetings at the time stated. All in favor say aye.
Aye.
Aye. That passes 3-0. Okay, we'll now move into our work session. I do ask that those who have, because we do have closed meetings that we've just passed, and we have a number of work session items. I hope that whoever is leading those work sessions will try to set some time parameters and stick to them. Even if they're somewhat broad, let's just be mindful of the time on this. So the first one is a presentation on Whittemore Road by Richard White and other discussion. And Commissioner Ivie, it looks like
Yeah, so
you have
we put this
introductory
on.
comments.
I had the opportunity to speak with Mr. White regarding this. He had some interesting points and details that he brought up on that conversation. I felt like it was appropriate that we host this for work session item so that the entire board could hear the presentation and the points, and that we could get feedback as well from other participants. So.
Okay.
My name is Richard White. Just wanted to thank you, commissioners, for the opportunity to speak to you again about this issue. And I have spoken to Commissioner Ivie and Commissioner Lee about this issue, and just wanted to bring up a couple of points in regards to Whittemore Road. Right now, the discussion is trying to come to an agreement with the county on if the county should take Whittemore Road or a portion of Whittemore Road as a public road. And I just wanted to speak to that. A couple arguments for taking it. It was brought up by Commissioner Ainge before, you know, what benefit or what, and I don't remember your exact wording, but how this would benefit the county or why the county should take it over. And I did bring up that it, you know, to me, it wasn't necessarily a benefit, but to me it was more of an obligation because of how the road is used and who is footing the bill for the road maintenance and who's using that. One major point with that is currently I have a piece of property that's off of Whittemore Road, which is undeveloped property, so it's just vacant land, which we do visit once in a while. It's not on a frequent basis. But then there are 3 other HOAs that are off of that road. One would be the Cottages, one would be Upper Whittemore, and one would be Springwood. Not very many people go into Springwood. There are no approved residences there that I know of. People go camping there once in a while. Whittemore has quite a few cabins up there, and they utilize the road heavily, both in the winter and the summer. And then the Cottages utilize the road as well during the winter and the summer. And then the public utilizes it all year round, whether it's to go snowmobiling, to get up to the backcountry, snow biking, hiking. All of those things happen on a regular basis on that road. One interesting fact is, you might know of, it's called Shadow Mountain. There's a camp up there for 5th graders that Nebo School District uses every year. They usually start towards the end of May and go till the 3rd week in July. And they utilize that road heavily during that time with school buses and trucks and vehicles getting supplies up and down from the camp. The camp does not lie in any of the HOAs that are on that road. The camp actually lies outside of the Whittemore HOA, but the camp utilizes the roads of Whittemore, and they also use their water system. When they do that, they do pay an HOA dues to the Whittemore HOA to utilize that. And so that goes to help maintain the Whittemore roads and pay for the water that they are using. The interesting fact, though, is the paved portion of Whittemore Road, Whittemore HOA does not help maintain one bit. And neither does Nebo School District. So Nebo School District, being a public entity, utilizes a paved road that is private currently, which is, Nebo School District is a public entity, an entity supported by taxpayer dollars, and they use it free of charge. They do have an easement, but they don't help maintain anything. To us, being a public entity, they should contribute to maintaining that road. And they've utilized it for, I don't know when the first time they got the property turned over to them, late 70s. And I don't know when they started using it, but it would have been in the 80s. I know I attended there when I was in 5th grade. And so as early as 87, they started utilizing that road and that portion free of charge. And so for that reason, that's one reason I do believe that it is utilized as a public road and should be turned over to the public. As such, do you have a question?
Can I ask a question? Yeah. So you're saying they should have to contribute, but didn't you also say they are contributing, but it's through the HOA?
So they contribute to Whittemore HOA.
Yeah.
And the only portion of the road that Whittemore maintains is the dirt portion,
Got it. So you're saying that, yeah, they're not maintaining the rest of
the
it.
paved portion. So their funds don't contribute to maintaining the paved portion by any means. And Whittemore doesn't contribute either.
Got it.
There's
And
only
then-
one entity right now.
And then I
that
just
does
wanted to
that.
connect the dots between your point about the school district. Does that, obviously, we're not going to make any decision today that is binding on the school district.
Correct.
So where are you ultimately arriving on that? Like, even if we all agreed that the school district should pay to use that road, what's the effect of that statement or that conclusion in
Well, that
your
we have a
development?
public entity that's utilizing the road. And to us, that should turn that road into a public road. And therefore
Interesting.
should be maintained by the county.
Okay?
So, and we know that this county commission did not, contribute in this issue one bit. But you do have a great opportunity to help resolve the issue. I'm going to step back a few years. So, in about 1975, the Springwood HOA was formed, and the plat map was approved. And they utilized that road. In about 79, the Upper Whittemore was approved and started using that road. I have not been able to find any road maintenance agreements that pertain to either of those on how that road should be maintained and taken care of in the future. And then you have in it wasn't about, in 1990, the Cottages HOA was formed and approved. And as part of that, they were required to sign a road maintenance agreement with Utah County, which required them to take on the maintenance of the paved portion of that road, 100%. So because of the ordinances and because of the approval process, they were required to maintain that pavement 100% by themselves, where
The paved portion of Whittemore Road.
the paved portion of Whittemore Road is required to be maintained.
And
by the
Robert, we agree
cottages.
with that? And is that standard practice, I guess, as a new development comes in, that the county, because at that point, that was a private road already, right? What business did the county have in making that stipulation?
That was a requirement in 1990, in our ordinance, that in order to have a development on a private road, you had to have a road maintenance agreement. In 1975 and other years before that, it would not have been a requirement of the county at the time. So in 1990, when that development came in, that requirement was there, and so that's what's happened.
Okay. So did they take that away from the pre-existing HOAs?
No, they just made an obligation on the 1990 development because.
Oh, because that was a new requirement.
That was a new
Previously, they
requirement,
they
correct.
didn't need to. Okay. got it.
Correct.
I'm following. Okay, sorry. Continue.
So to go to that point, so we have an HOA that's formed in 99 that the county, because of the ordinances, requires them to maintain a paved section of road that's almost, it's about 3/4 of a mile long, that they have to maintain that 100% by themselves. There are 35 lots in the cottages. If you take Springwood, which is over 80 lots, and you take Upper Whittemore, which is over 120 lots, so you have 200 lots. They get to drive on a private road that's paved, and they get to do it for free. They don't have any responsibility to maintain it. But the county forces an HOA with 35 lots to maintain it 100% by themselves. And that's because of the ordinances and them wanting to access their HOA off of a private road. And so now we come to today where we would like to put 3 lots off of that road as well. And jumping into this quagmire that's been there for years and trying to figure out how to navigate all of this, where 2 HOAs don't have to do anything, one has to foot the bill for everything, and now we're stepping into this wanting to develop our property and utilize it the way that the county ordinances allow us to. And so where I'm trying to get with this is I believe that through the ordinances and through what has happened in the past, that the county has forced a road that was private because of not getting other HOAs and them not being required to contribute, now forcing one entity to pay for everybody's use and not just taking it over as a public road, where it's being utilized as a public road.
So
have
what
questions,
exactly is
Commissioners?
your ask at the end of that presentation?
We ask that the county take Whittemore Road, the paved portion, and the portion that we would pave, which would be approximately another 375 feet, as a public road. We have agreed that we will get it up to the county standards, which we've been told by Richard Nelson that we would have to put a 2-inch overlay on the current road, which is a substantial cost for us. But we're willing to get it there so that the county engineering office is good with it, so that the county would take a brand-new road, and then the county take it from there and maintain it from there on out. That's what we are asking.
So if you're willing to pave the road, to turn it over to us, what's the challenge? It's not really your property, it's another HOA that has the obligation to maintain this road right now?
It is.
And so your interest in what exactly is your interest in the county making this a public road?
Our interest is for one, it's being used as a public road and it should be maintained as such. And if we were to try and use other means, which we have tried for, a good part of 2 years, and haven't been able to come to any, agreements with it, but we would end up having to contributing to maintain that road as well. And therefore, we would end up with 38 lots that are maintaining something that, right close to 240 lots are using. And so we still don't see, why it should be placed the burden on 38 lots that 240 are used. And so going back to my statement earlier, that due to the county ordinances and regulations changing over time, we've got a road that was private that is now being used as a public road and should be maintained publicly instead of privately.
So is it your understanding that right now you could build on your lots, develop, and that the only concern is that you and the neighboring HOA would be paying a disproportionate cost of that road maintenance?
Currently, as it stands, we are not able to, because the county attorney's office has not recognized our easement rights, which we believe are there. And so we're trying to come up with other options. And we do believe, even if those easement rights are there and we could use them, I still believe that this road is being used as a public road and should be maintained as such.
So that's what I thought I had recalled an application for development that claimed easement rights there. And so
Yep.
if the easement rights was recognized into the neighboring HOA, then you would have the right to build. Is
Correct.
that correct?
Mhm.
But then you would be left with the concern of, that you've raised, that it would still be a disproportionate cost.
It is, yes.
But would that disproportionate cost outweigh the cost of completely repaving this, just to turn it over to the county?
So what you're asking me to try and figure out is what's gonna be the future costs of it.
Yeah.
And I can't project those future costs.
Well,
on-
and-
on what'll happen to that road. And so to me,
And to be fair, what I'm also kind of getting at is this really about a road maintenance issue? Or is this about development? And I understand it, but I think you've made the case that they're both issues, and they are related.
Well,
I would agree with that.
this whole issue came up, looking at development and how development can happen. And so obviously there's a development component that's tied to it. And, and for me looking at it, I was trying to find some solution to it that would work. And the best and easiest way in doing that is for the county to take over that road, which I agree, it acts and functions as a public road now. And in many ways, it's already at that standard. It just doesn't have that stamp of approval on it as a county road. And instead of going through, we've already had, threats of all kinds of lawsuits and lawyering up and everything that's gone on with this thing. It seems like it's an easy process for us as a county to look at it and say, this thing looks like a public road, it acts like a public road, it's got many characteristics of it, it's just not. And so, why are we dug in so hard on this thing, trying to push one way or the other with it when it acts that way? And that's my perspective as I've looked down through it, and it solves so many of the issues up there. Ultimately, neighbors want to be neighbors. Neighbors necessarily, and I think good neighbors don't necessarily want to be suing each other back and forth all the time, always involved in litigation. And so it allows for, the county in this instance to to be a partner in there with that, you know, some of the development that is going on up there in that area.
And to go back to your question, thank you, Commissioner Lee. To go back to your question, you know, like I said, we started this process well over 2 years ago to push this through. And this is the absolute closest that we're coming to resolve this problem. 50 grand is 50 grand, and I don't have 50 grand right now. But this is my only solution at the moment, my only good solution that I feel like will solve all the problems to push this through. And so I'm willing to do that. Do I want to? No, I don't want to pay 50 grand by myself. But it's cost me 2 years, quite a bit of money, and, you know, I feel like this is a solution that's a win-win-win. You know, most everybody will be able to feel like it's a win, and the public will be able to start paying for something that they use. And right now, they use freely.
Any other comments on this?
I appreciate the comments and the opportunity for the public dialogue. Didn't know if there was any other public comment that would be interested in sharing their thoughts.
As people are coming up, I'll share some additional thoughts. I mean, I think, Richard, I appreciate the way that you presented this today and that you have in the past. I'm certainly sympathetic for your efforts to develop your property according to rights that you have asserted exist. And I do appreciate the efforts that so many involved have done to try to come to a mediated solution here. I would say that maybe my biggest hesitation is simply that it's unfortunate, let me put it that way. It's unfortunate that the neighboring private property landowners cannot agree on what the rights are. And sometimes that does just need to be resolved, even if it's through litigation. Or, you know, some sort of agreement between the parties. And this is something that the county could do, and, you know, I'm open to. If we get in the business of mediating between private landowners, especially through the process of taking over roads, that does create a little bit of an interesting precedent. And so that's the one thing I'm mindful of here. But I'm aware this has a very unique history.
Sorry, just to go about that, and that's why I went back into the history, is through the ordinances and the rules that were in place at the time that all of these HOAs came about. That's how some of this was created, was through those ordinances and rules by the county. Is they created a public road that was used by lots of people, but was not, and is not being required to be maintained by everybody. And so that's why we think that the county should be helping out to resolve this issue, that the county has some culpability in creating the problem, therefore the county has some culpability in helping to resolve the problem.
Thank you. Other comments?
I want to tell you that my name is Janice Reeb. I live in Hobble Creek Canyon. I don't live in the cottages. I do have an interest in this development process up in Whittemore. It's extremely frustrating to me because for a very long time, I have come before the commission and asked them to look at the broader map. And that has not been something that has been able to have been done. We have insisted on looking simply at backcountry as if it is the only issue. The pieces of this have come together over time for me and for those of us who have been here on several occasions. I'm very appreciative, especially of Commissioner Lee's efforts to try to resolve the problem among private property owners to everyone's advantage. I also appreciate, Commissioner Ainge, your looking at the precedents that will be set if a private road is taken over and made or a public road is made of a private road in the future. But what is really troubling to me is the obfuscation and the misstatements that I hear every time I come here. For example, the statement that the county has culpability because it did not enter into an easement agreement with Springwood Plats A, Plats B, and Upper Whittemore Plat A is simply incorrect. If you go back and look at the history, which I have, there are easement agreements and maintenance agreements with all of those subdivisions. If one looks at the entire map, what was in place in 1975 through 78, 9 is exactly what's in place now. And the law says that for safety reasons, it is necessary for there to be 2 access egress points from every subdivision. There are, if you look at the map, we are not talking about 67 acres or even a third of that, which is 422 acres. We are looking at a watershed that is 1,396 acres. It is, pardon me, the most important single watershed to come into Hobble Creek. Hobble Creek is the main focus and contributor to the Springville irrigation system. That water that comes down Hobble Creek through the canyon also goes through Springville City, Mapleton City, and provides their irrigation and culinary water all the way to the farmers on 4th South into Utah Lake. I didn't understand what an immense issue this is. I have deigned to come here again and beg that we look again at the whole process, because the county is looking at being in the position to develop and pave over not just 67 acres for backcountry, but, and I would ask you again, I'm not steady on my feet. Richard, would you pass these? I just need to keep on. It is true that Mount Nebo School District has a camp up in Upper Whittemore, but they use it in the summer. It is true that the public uses Whittemore Road, but that is a private road with a public easement. That easement was put in place as an easement appurtenant way back in 1975 and 76. I know that it takes a lot of patience to listen to me, but it is important that we look back that far, because the county doesn't have culpability when it comes to not entering into easement agreements. If you received my email, you know that I tumbled down the stairs at Central Bank on last Friday, and I threw all my paperwork up in the air because I was carrying a box. I can produce those documents and show you those easements in chronological order back to 1975. Why am I particularly interested? I'm interested because of water. I'm interested, ironically, because of Richard White Sr.'s water. I'm interested because there's an adjudication going on right now. It's been in place for 30, I don't know, however many years. I'm not good at the math in my head right now, but since 1986. I thought I was just helping my neighbors because the majority of them depend on Upper Whittemore, on Hidden Creek Water Company well for all their water needs. And now I depend on that also, the drainage out of Whittemore, because it's declining. That's why we have an adjudication. That's why it's now being funded by the state legislature. And that is why we are about at the cusp, because I have been working with those attorneys for Springville City, for Springville Irrigation Company, and in behalf of myself, because my water rights, you have said, Commissioner Ivie, just because you have a right doesn't mean you have water in your ditch. It also comes down to water for development. If you will look at the very last sheet in that pamphlet, you will see that when we talk about backcountry, 67 acres, which I think is in blue, we are talking about.
And Janice, I
Sure.
do need to ask you to try to be
Sure.
brief,
I-
because
it's
this
very-
work session was scheduled, this is actually not a public hearing, and there's no action being taken today, so the work session was scheduled for Richard to present. And
I
so
would
this
like
is,
to
we
re-
allowed public comment, and so just want to be clear.
I appreciate that, but I will tell you that I have been here 4 times before, and the first thing that's been said to me, including a public session, a work session scheduled for us, was 3 minutes. I will try to be as brief as possible. These are the reasons we came here 4 times. The first time we came here, it was because of the issue of whether or not there would be access for backcountry. There is not a legal way presently for backcountry to be able to access and develop. Simply doing their public, the county taking over their public right won't do it either. It would make it possible for them to develop their land, but they don't have the water. If you would, let me try to shortcut it. As I have been researching, what I discovered was, number one, the easement issue doesn't have to do with 6 lots, it had to do with 83. The people in the cottages did not want 83 households coming through their private property, and they don't have to, and I could show you why. Number 2, the easement issue had to come with mixed zoning lots. And if you will look at that last diagram at the green, you will see that this subdivision for the 120 lots in CE2 will be, or is able to be, subdivided now for 100 lots. We had Keith Haslam, and we contested that issue because Keith Haslam wanted to reduce the square footage for a home from 1,100 to 350. That would mean, again, that the 120 acres that are on this in the orange would then be able to be divided into quarter-acre lots with a small home that meets the setbacks. The last time we came was whether or not the whole process was fair and just, and it isn't. It is an obfuscation. I understand that Richard and Leah want to have their dream. I understand that. I have children and grandchildren, probably their ages. However, the people in the cottages also have dreams. Their property and my property. I wish, Commissioner Ainge, when you said that you drove up there and you just didn't understand why neighbors couldn't get along, you knew the whole story. I wish that you had come to my property also, because the water draining out of Whittemore Canyon is half what it was. That means the developments that we have put in place will not be available in the future because our pumping system won't work.
Well,
I
I'll
know
just-
that's a huge piece, but I urge you to listen to the entire story, and it cannot be told in 3-minute sound bites, and it is not what's been presented here.
Dennis, can I ask you a few questions?
Really?
In trying to understand this, and you can maybe clarify. In talking with you, you're not necessarily against Richard White and development of three
Never
three
have
lots.
been.
And I think that as I've tried to understand where you're coming from, it deals primarily with the water and the water, and this is where it gets fuzzy for me.
Okay.
Is that with Richard's development of 3 lots, he has to get, or maybe has, I don't know what the answer is, he has to get water from somewhere. There's only one water company up there that I know of that can give that water. And the fear is that if that water is developed down into his property, that it opens up all the other possibilities for development over on the other side of the cottages. Is that?
That's the capsulization of that, but it's deeper than that. In looking at the records in the Office of the Planning and Zoning Commission, Carol Herbergson and I found a document that is a willing to serve letter that is not recorded. It's between Tracy Tanner, the developer of the 120 acres in Gold, and Richard White. Their agreement is that if Richard White completes an expansion up to her well, that will make it possible for her to rejuvenate the lots that she has. That's because the water source to Springwood A and B, if the county wants vulnerability, that's where it is. Those people have purchased lots thinking that they have water, and they don't. And Richard doesn't have water either, unless he follows through with the easement with the willing to serve agreement that he has with Tracy Tanner. He does not have water to his property. Those lines have been cut, and when we talk about 128 lots up Whittemore, there aren't any anymore because there's no water. Because only 43 of those lots have been proven to have beneficial use. Those water companies were sued by Tracy Tanner, and I am hugely concerned about being sued myself. Everything I have told you is the truth. Everything I have told you, I can document.
Well, maybe I can suggest.
Go ahead.
Bryce, if you'd look into that, because it's a fuzzy area that and Rob too, on what that is, or maybe Richard can, tell us a little bit about what the intention is, with that development of water down to his property there.
It's not just to his, it's to also the 120 lots also.
Right, and so, if there's agreements that way or not, I don't know. I don't know if necessarily if it's the county's position on this, or if we're just looking at the lots themselves and let the development happen where they are. Those are just questions that I have. It'd be interesting to see where that is, because it's really fuzzy for me when we start talking
And
about
I
that side.
understand it. It was fuzzy for me for literally 2 years also, until I discovered that we are not talking simply about backcountry. We're talking about 422 lots on the south of that and 120 developable lots on the east side of the cottages. That's of concern to me because I drive the road.
Sure.
and because it could double the population in the county, even in the canyon, even if water weren't the issue. I thank you for your time.
Quick question, because
Surely.
I just, and circling back to the road itself, I appreciate your bringing up that this is a broad issue, and this is one component of that, right? And we eat an elephant one bite at a time, and I think what we're trying to do is take some bites here.
I
Do you
appreciate
feel
it.
that making this a public road is beneficial for the residents of the canyon?
I do not.
Okay, answers my question.
Thank you.
Thank you.
Okay, I would like to try to close out this work session. If we could have remaining public comments be brief, thank you.
I plan on being brief. I'm Dion Barron. I just want to make one more comment that Richard and I have discussed and should be part of what you're considering right now. But because I live in the cottages and the burden that we carry there is also a heavier burden because the county hasn't followed through on the original agreements that the other HOAs had with the county, that they would be only occupied for 180 days. And because you don't follow through with that ordinance, they live there 365 days a year. And so the maintenance that we're required to do on that road is a 365-day maintenance for those up above, because the county isn't enforcing the original intent of those. So that's another reason why I think you should consider taking that road and making it a county road, because you've created a burden on us that was never part of an agreement. Thank you.
Okay. Any other items on this work session up here, commissioners?
No.
Okay, thank you for those who have participated. We'll go to our next work session item, which is related to an ordinance for solar energy operations.
Okay, this is Bryce Armstrong, Community Development. If I understand my instructions from the chair, I need to be brief. So I will try and do that and just answer any questions. This is a land use ordinance text amendment to amend a portion of our land use ordinance that deals with our planned community zone, the Goshen Valley Planned Community Zone. The staff report indicates some little history on the PC zone. I won't get into all of that, but just as a brief summary, in 2009, the county commission adopted a new zone out in the Goshen Valley area in anticipation of build out of a community type setting that would take over years and decades. And so in crafting that zone, there were certain layers of development stages or development approval processes. And also the zone contemplated existing uses that were to continue while this build out happened over a long period of time. Those existing uses mirrored what was previously allowed in the A40 zone, which most of the zone, the area that was zoned to the PC zone was. And then also it contemplated adding some additional uses such as gravel operations. Several years later, there was an amendment to allow temporary motion picture studios. If you're familiar with that area, there's an LDS motion picture studio that is contemplated to exist while this build out happens. The present request is to add to those existing uses that do not invoke the overall development plan of the PC zone, but allows these to exist in the interim. And this use is related to a solar facility, solar generation facility, a solar farm. And so that's what we're here for today, is to contemplate adding this type of use as an existing use, subject to going through a conditional use process, which those other existing uses go through. One thing of note, the area designated as proposed by the applicant is limited to only a portion of the PC zone, a specified area that's defined in the text itself of the proposal. 6,000 acres is what this area would currently entail. And I think there was some strategy to that by the applicant, and they can speak to that. I think the applicants are present. So that's kind of what this is for. The Planning Commission recommended approval for this.
For you on that,
Yes.
if I understand it correctly, on that area, because that was always part of my concern is that it's broad, but, you know, you're talking about it being narrow in scope. And the area, as I understand, narrow in scope, does not have any agricultural protection or any agricultural necessarily use, except for probably grazing, limited grazing in that area. Is that?
I'd let the applicant speak to that. I can't recall what the aerials showed, but there may be some grazing type of uses, but I think the production agriculture is elsewhere.
Elsewhere.
I would ask a question. It sounds like they're maybe coming up to make a comment, and if you could address perhaps in your comments what impact would these changes have as it relates to kind of general economic development of the county and of this region of the county, since I know that was a consideration when this original zone was created.
I'll kind of let the applicant speak to that. I know there has been a number of these solar farm facilities, inquiries about siting these out in the west portions of Utah County relative to some of the energy needs a little further to the north in some of the Eagle Mountain area, some of the operations that are going in place there. There's some needs for green energy, and so I think these facilities are hoping to fill that need. But I can let the applicant speak a little more on that.
Well, I think, there's two aspects to this. One, and I can't remember if it's called a 45K line. I don't remember what that is. There's at least an opportunity to tie in, you know, to the line there. That's a big draw because a lot of solar companies are looking at it because of that. Second, in that area out there for development, a lot of these manufacturing facilities or others that are possibly looking at an economic impact in that area, which it's been designed for, they're very favorable to the green energy types. I mean, they want a certain percentage of that coming. So I think those are the two that I have heard anyway. Going back to the economic side of it, is that one, there's a line that they can possibly tap into with Rocky Mountain Power and feed back in, and second is that companies would prefer to have that type of energy if they can.
And then, sorry, last before the applicant speaks, can you just refresh us on where the planning commission landed on this?
Yeah, they recommended approval. I believe it was unanimous, and staff feels that it's consistent with the general plan. There is some language in there to allow this to continue over a period of time as long as it's consistent with the development plans as build-out happens. So I think that's built into this.
Good afternoon, Commissioners. My name is Wes Quinton. I represent Ag Reserves, that is managing the church property out in that area. Just to answer the first question, it was about what some of the land use is out there. There are approximately 3 pivots that would be impacted by this solar array if it goes in. The rest is currently in grazing and trekking. So we're getting a little bit of feedback about that, but we think it's a good move. And as was already discussed by Bryce, this was planned for in 2009. The county approached us and said, can we do a large master plan type activity out here? So we had a specific area plan that we put together that covered more than 62,000 acres, I believe. And then we put our 26,000 acres under the PC zone. So we're asking for approximately, as Bryce mentioned, 5,000 acres, and I think the development is going to be about 2,500 acres or potentially a little bit less that will go into this industrial solar array. That obviously represents a small component. The county may want to consider at some point their A40 zoning, because if we had just changed the A40 zoning to make solar use a conditional use, it's going to solve a whole host of problems when you have solar companies coming before you. But we were limited in what we could ask for because of our nonprofit nature. There are specific tax regulations that if we make substantial improvements to our property, we have to hold for a period of time. And if we had made this a global change, it would have impacted all of our property in Utah County. So we had to just make it very small, in particular to the current solar project that's going forward, so that this 5-year hold wouldn't affect everything that we wanted to do in the future here in Utah County. But again, we appreciate the consideration. We believe that there are other opportunities that we've had with solar companies as well, one near Fairfield, close to Facebook. They're very interested, I think, in some sort of offtake agreement, but We'll see if that ever happens. So this is something that, as an entity, we're very interested in promoting because we believe it creates some sort of sustainable energy as well in a very economical fashion, and it creates that anchor tenant, that catalyst out in that region that we can then use to bring in additional industrial tenants, which is more along the lines of what the county was looking for back in 2009. Any questions? I kept it as brief as I could.
I guess I do have a concern that I'll state here, which is not so much about this land use, but some of the solar projects that have come and have made initial discussions have asked for a tax increment financing to help finance. And that's not something that I have been supportive of. And it's one thing to allow for this, and this seems like something that the Planning Commission has supported. I think it's something that I can support today. We're not voting on today, it's just a work session. But can you comment on, whether that would be sought in this development?
I honestly don't know. Long Road would know. They could answer that question, but as an entity, you know that we don't generally participate in subsidies of any sort.
Good afternoon, Commissioners. My name is Brian Harris. I'm with Long Road Energy. We've been active in developing wind and solar projects, utility scale wind and solar projects in Utah for the last 15 years. The first project we developed in Utah, just by background, it was the Milford Wind Project down in Beaver County, 300 megawatt wind project, 165 wind turbines. I don't know if you're familiar with that. And then subsequently we developed 15 utility scale projects, mostly in Beaver and Iron counties. We've been very active in this space in Utah, and we're the developer for this project on farmland reserves property. So I'll try to answer a couple of the questions, but please remind me, I may have missed a few. But this is a great location for solar development. There are multiple large transmission lines that run through this area. I think there's actually 5 345 kV lines that run through this area. So that's one reason why it's an attractive area, a good solar resource. And it's, there's growing demand for solar energy, not only for a lot of the tech companies that are moving into Utah, but also just generally for the load. The cost of solar has gone down tremendously, and it is, it's on par with other power producing plants such as coal and natural resource or natural gas. So it's generally just it's going in around the country, and in Utah, load obviously is a Wasatch Front. So the closer you can get to load, the less constraint there is on the existing transmission lines in Pacific Coast system. So that's why you're seeing a lot of growth in Utah County and in northern Utah in particular right now. To get to Commissioner Ainge's question, yes, we would like to seek a tax increment financing for this project. The reason being is the project is very, there's lots of competition for these projects. And the project will be competing against other projects around the state and even outside of the state of Utah. Multiple states and, for example, Nevada, they just have a blanket, no property taxes on renewable energy projects. Other states have that. Other counties have been offering different types of tax increment financing. So that's what we're competing with. We think it's great economic development to take ag land that's mostly just grazing, so very little taxation, putting a several $100 million project on that and creating more tax revenue for the county. But it would be necessary to have the tax increment financing, most likely for the project to be competitive with the projects it's competing with around the state.
I've got a question you may or may not know the answer to. It's in relationship to the latest data coming out on the sun itself, in relationship to it going into a solar minimum. Does that affect solar power plants and their capacity for production at all? I'm not really familiar with the science or technology behind those in intimate detail, and I was just curious if you guys, being in that industry, may know or not know if a grand solar minimum would affect the output capacity for solar, for solar powered energy systems.
I am not familiar with that.
Okay. Well, I'm glad that you could address that, because it will weigh into my decision as this goes forward. The default position that I am in economic development is that no tax increment financing. I think that there are businesses that want to come here because of the attractive tax rate that we already have, because of the talent pool, because of some of the other resources that you've mentioned. And I don't think that we need to continue offering additional incentives above and beyond that. Certainly not handing them out without a lot of scrutiny. So this year we have made changes to how our economic development program is administered. And, there's also, anyway, I think we have all expressed some frustration with that process and how it's worked. So I think there's still a lot of convincing to be done on that front. And obviously multiple entities are involved. But this one is an interesting one because it's kind of tied to a zone change. So at least in my mind, I guess I'm mindful of that, but I appreciate you being open with your answer there.
Thank you. Any other questions?
I might just address one more point. I should have expressed this earlier. We are in a lease arrangement with Long Road, so we'll maintain ownership of the property. They'll maintain the ownership of all the improvements. So just to understand our relationship.
And Rob, if we could ever get away from permitted conditional use, it would make me so happy. Just so you know. This seems odd to me still.
I'd probably support that also. Just one
As a side note.
clarification. This is, as Commissioner Ainge mentioned, this is just a text amendment. The applicant would then need to follow up with an actual conditional use application for his specific project to the Board of Adjustment.
Okay, you're back, Bryce. I mean, any other additional comment on the second work session item? Okay. Item number 3, grading, fill, and associated excavation.
As a matter of clarification, I guess, on all of these, is this something that would be moved at the commission's discretion to a action agenda?
Correct.
Okay, so staff doesn't have to redo a commission agenda request for these again.
It looks like their language is action, except for number 1. Number 1 would need to be redone.
Sure.
Right.
But 2, 3, and 4 looks like they're in forum to be placed onto an action agenda.
Okay, Bryce Armstrong again. This is a kind of a follow-up housekeeping text amendment. If you recall, the county commission amended the county code several months ago to adopt Chapter 32, the stormwater regulations. And so this is just kind of a follow-up to those. Certain sections of the land use ordinance referred to grading and fill and grading permits in instances where that is now handled through the land disturbance permit process. These amendments were recommended to just reflect that, to mirror that new process. So, simple as that. Again, favorable commission recommendation from the planning commission.
I don't have any further discussion on this item.
Questions on this one?
Okay. Item number 4.
Okay. If you recall, this was an action that was referred to the planning commission by the county commission relative to development types that are permitted in the residential, rural residential and the RR5 and the transitional residential TR5 zones, specifically looking at planned unit developments. And so just as a brief background, the county has had an RR5 and a TR5 zone since the late 70s. Those zones have served different functions over the years. and have allowed different types of developments in different formats over the years. And so as things have progressed and the way those things have been utilized, I think it's become clear, both to the staff and perhaps to the commission, past commissions, as to why this maybe was referred back, that permitting certain development types and the densities associated with those types of developments in areas that are adjacent to cities or within a city's annexation policy declaration seems to be in conflict with the county's general plan policies of encouraging higher density residential growth in cities, in municipalities where those services exist. And so I think in harmony with those policies, it would make sense to, at a minimum, recommend, and this is what the Planning Commission came up with and passed on to you, eliminating planned unit developments in both of these zones. Planned unit developments allow a base density of 2 units per acre, but allow up to 3 units per acre, contingent on having a water system and a central sewer system, and also allows attached units that that can be spaced at a very high density. And so it's recommended that planned subdivisions obviously need to remain to allow people to subdivide land, and so that would remain. A planned subdivision in the RR5 and TR5 zone has a similar base density as our RA5 zone. It's 5 acres minimum lot size, but if you do have a central water system for a planned subdivision, you can go down to half-acre lots, 20,000 square feet. And so that has remained. PUDs, those just haven't been utilized. I think it's quite challenging to meet those requirements. The last one we had was a little 5 or 6 lot one down in Spring Lake that had an existing water system. Prior to that, there were a number of PUDs that were approved as part of the build out and development of Saratoga Springs. I think that was one of the original intents to allow those. As you heard in our past application, we have a PC zone that now kind of acts as a seed to create building new cities, and so if a large property owner had that desire, that option could be available through the PC zone process. And so that's kind of a real brief summary. There was a letter from Spanish Fork City that I think was included in your backup that was in favor of this. I know there have been some of these issues that arise with different cities throughout the county when this perceived density is allowed, and that kind of conflicts with perhaps what the city's goals are, and so you can kind of appreciate the situation that presents itself sometimes.
Thank you for this. It's interesting that you brought that up with Spanish Fork too, because I can see where the commission went in the past with allowing kind of a direction, but I agree that the development, as has been the past practice, the high density development should happen in the cities, within the city limits. It just makes sense for that to happen. And in looking through this, I see some of the conflict between Spanish Fork City and what's going on with Provo over here, with the foothills area, and possible other areas that would like to do something. But this is looking at it on a broad scale with the TR5s. It would apply to all.
Correct.
I would love to to even explore. Hey Josh, are you taking off to go home or anywhere? Okay, because I need you back for a closed meeting. Okay. Explore some of the options, because what I don't like is the beating stick that seems to happen with it, where you have, well, the county will let me do it over here if you don't allow me to do it on this one, and then we get the county against the city. So I love the fact that we're looking at some cleanup with it, or trying to clean some stuff up. But it also goes the opposite direction, where, we're almost, in some cases, I'm worried about taking away some of the rights that they already possibly have, and now, reversing it too. So it's a tricky one. I'm still trying to work down through it. But I am generally in favor of all the development going on within the cities, and that's kind of my overarching, opinion when it comes to this, and how we work down through it.
Well, I appreciate this, Bryce, and the work of the Planning Commission, and I'd echo Spanish Fork City's letter a little bit there, and Commissioner Lee's comments. It's I think consistency is one of the greatest things we can strive for when we're dealing with land use ordinances, and it's been a consistent policy for these types of developments to happen in incorporated areas. And I think keeping our land use ordinances, you know, tied to that vision is important.
Okay, thank you.
What's, just, I guess one follow-up on that. What's interesting is the original intent of the TR5 zone was to act as what we now have as the annexation policy declaration. That was
exactly.
applied in working with each city.
Right.
Doing a drainage plan, a road plan, and so it's kind of got a different purpose now, and so we're trying to match those. So.
'Cause it sits as that TR5, you know, and it doesn't actually annex in. It almost is like, to me, it almost seems like we should have a TR5 and say, well, we're gonna have a TR5 for 2 years or 5 years, and then it's gonna go away, because unless you're gonna transition into the city, you're not really, but you can't do that. But I'm just saying that it seems like we should have some sort of transitional time limit on it.
Sure.
So I would think with these work session items, you know, personally, that they can be placed on our agenda. Of course, it will take one commissioner to click off on it if you know, to go onto the agenda.
Thank you. All right, with that, we've concluded our work sessions. Is there any additional public comment? Seeing none, we will move into our closed meetings.